This week, the ATF dropped yet another gun control bomb on the American public. This time, it's aimed at private sales of firearms. Why? Because if it's a private sale, there's no background check. And if there's no background check, there's no way for the government to track it. And that is exactly what the left has been working to eliminate for decades. This rule basically gives the ATF a blank check to declare any private sale to be made by a firearms dealer and prosecute that individual for then selling without a license. The rule specifically does not give a threshold for how many gun sales it takes for you to qualify as a dealer. It does that specifically because they want the discretion to declare any private sale to be made by a dealer and be able to prosecute accordingly. And so what they're going to use is what they call a fact-specific inquiry, which is just ATF speak for it's entirely up to us, and we'll declare it to be a dealer sale if we want it to be one. And that leaves the American public at great risk of criminal prosecution without even knowing what will qualify and what won't. But before I get into that, I want to back up because this is a little different from most of the ATF fights we've had up till now. So most of the time when we're fighting the ATF is because the ATF is twisting the words of Congress to mean what they want it to mean so that they can then go after something that Congress never intended. Like the pistol brace ban. They twisted the definition of short-barreled rifle to then allow them to ban pistol braces, which is not something that Congress authorized. Same thing with forced reset triggers, same thing with bump stocks, etc., etc. So normally what you can do is bring a lawsuit pointing out that the ATF is not acting consistently with what they're authorized to do as an executive agency by Congress. In other words, they're writing the laws. They're not enforcing laws that Congress actually passed. But this is a little different because that is not what's happened here. In this case, Joe Biden's ATF has teamed up with Congress to ram this set of gun control down the throats of Americans. And it all started in 2022 with the Bipartisan Safer Communities Act, so-called. We call it here the Cornyn-Murphy deal, because we don't ever want to let people forget that Republican John Cornyn is responsible for this deal. Now, there are a lot of really bad, really concerning gun control provisions in the Cornyn-Murphy deal. I want to talk about one of those today in particular, because that's what laid the groundwork for the ATF's rule. They redefined basically what it means to be a gun dealer. This didn't start with the ATF rule. This started with the Cornyn-Murphy deal. In that bill, they basically redefined a key aspect of the gun dealer definition. So a gun dealer is somebody who's engaged in the business, right? So what does engaged in the business mean? Well, originally, it meant that, according to U.S. Code, they did it with the principal objective of livelihood and profit. So the Cornyn-Murphy deal changed that to predominantly earn a profit. Okay, so what does that mean? Well, they give us a definition of that too in the statute, and I'm going to read that for you because this is very significant. The term to predominantly earn a profit means that the intent underlying the sale or disposition of firearms is predominantly one of obtaining pecuniary gain as opposed to other intents. Now, why is that significant? Well, it's because the ATF literally took that language and mirrored it in their new rule, and they built on that. Okay, remember what I just read? All right, now listen to what the ATF said. The intent underlying the sale or disposition of firearms is predominantly one of obtaining pecuniary gain, as opposed to other intents, such as improving or liquidating a personal firearms collection. Okay, so you see it's very, very similar. And you see that the language that Congress used is extremely vague. Why? Well, it's on purpose. It's designed to allow the ATF to do exactly what they did in this rule, which is expand on that and build on that. So let's dive into the specifics. Now, there's a lot in this rule that's really concerning, and we're not going to have time to get into everything. So I'm just going to hit some of the highlights and just really drive home just how concerning what the ATF is doing here is and how very, very unconstitutional it actually is. So they redefine engaged in the business as a dealer. It's a person who devotes time, attention, and labor. How much? Doesn't say. To dealing in firearms as a regular course of trade or business to predominantly earn a profit through the repetitive purchase and resale of firearms. What does repetitive mean? How many is too much? The term shall not include a person who makes occasional sales, exchanges, or purchases of firearms for the enhancement of a personal collection or for a hobby. Well, what's an occasional sale? How many or how frequent does it have to be occasional? We don't know. All right, then, so how do you know if you qualify? How do you know how the ATF is going to enforce this? Whether a person is engaged in the business as a dealer under paragraph A of this section is a fact-specific inquiry. A fact-specific inquiry. What does that mean? It means it's a blank check. It means there is no solid, reliable criteria that's laid out to where you can know before the ATF shows up at your door whether or not you qualify or not. Selling large numbers, again undefined, of firearms or engaging or offering to engage in frequent transactions may be highly indicative of business activity. Now here's the clincher. However, there is no minimum threshold number of firearms purchased or sold that triggers the licensing requirement. Blank check. That is what this is. And that is not the function of an executive agency when you're talking about criminal penalties. I should point out that there is no minimum threshold now for how many sales will constitute you as a gun dealer. But what this rule does is throws the floodgates wide open for almost any private sale to put the seller in danger of being classified as a firearms dealer. So just a couple of resales could have the ATF breathing down your neck. I also want to point out really quick that you don't even have to sell the gun to be considered a dealer, because it says selling large numbers of firearms or engaging or offering to engage in frequent transactions may be highly indicative of business activity. How many times have you been in a store perhaps and you saw something you know a friend's looking for and you see it's a good deal, so you go ahead and pick it up for them and they reimburse you later? That sort of thing happens with guns all the time. How many times does that have to happen? How many times do you have to offer to do that before the ATF is going to start eyeing you as a gun dealer? When you're not a gun dealer, you have no intention of going into business as a gun dealer. And yet, because you're doing this sort of thing, now the ATF can declare you a dealer at the drop of a hat, they can prosecute you criminally, and at the very least, they can force you to go through the entire rigmarole of regulations and background checks that gun dealers go through. That's what we're dealing with here. Then the rule goes on to say this: for purposes of this section, a person may have the intent to profit even if the person does not actually obtain the intended pecuniary gain from the sale or disposition of firearms. In other words, you don't even have to make a profit to have the ATF breathing down your neck calling you a firearms dealer. That's how outrageously broad this rule is. Now, there are things that you can do that create, with the ATF, a presumption of guilt. Now, that doesn't apply to criminal proceedings, but it absolutely applies to lawsuits against you, and that is one tool that the ATF uses sometimes to go after people. Or it can also apply to administrative proceedings, again, with the ATF. In those settings, these things will create a presumption of guilt, and you have to cough up the evidence to prove it's not true. So the question is, can they do this? Well, no. Under the Second Amendment, they absolutely cannot do this. But under the Second Amendment, Congress couldn't do what they did. But rest assured, we will not let the ATF get away with this. So stay tuned. Make sure to like this video, subscribe to our channel for updates. We will update you as soon as we have more specifics on what the game plan is. If you would like to help us fight back against Joe Biden's ATF and the unconstitutional gun control that we're dealing with here in the Cornyn Murphy gun control package and whatever else, please click the link in the description below to donate to our legal war chest and help us fight back. Thanks so much.